Have Pleasant Lake Park plaintiff.
Your name?
Ryan Oberholicki.
Caitlin Childress.
Say again?
Caitlin Childress.
Okay. Now,
Yes, this couple's back again in front of Judge Simpson. They're harder to get rid of than black mold. Will we get a conclusion to this case? I surely hope so.
where are we on this, folks?
Your Honor, on December 31st, Your Honor, set this again for today for essentially a status conference, I would call it, where there was, it was brought to the court's attention that the property was uninhabitable, using that term in a general sense, and that Ms. Childress and her 2 children should attempt to vacate the property sooner than the 30-day notice. And that's where we left it. I don't have any other information.
Okay, and I think we gave you the information to Hawk and other things. What happened?
Me and the kids are staying next door.
Pardon?
Me and my kids are staying next door with the neighbor. My son's finishing out this week, and then my mom's getting me a truck. She couldn't get it until this week. So, I mean, by the end of the week, all the stuff should be out. I called Hawk, but their appointments are scheduled out until April. And then she emailed me a list of things to get a hold of. So,
Of places to get a hold of to do that. All right. So, Mr. Olicki, you're out of the premises. Is that correct?
For the most part, I was just staying there temporarily, just helping her pack. That's it. But I'm my mom pretty much, so.
Okay. And your mom's getting you a truck. And if the property's vacated by the 23rd, then you guys are not going to have an issue with it going back to the landlord.
No.
Okay. That actually may work then. If you can try to do it by the 22nd, it would be appreciated. But what I'm going to do is I'm going to then adjourn this matter to February 23rd. At what time of day? I'll just put them into a regular block.
And Your Honor, would you like to discuss the counterclaim and that sort of stuff today, or?
Yeah, let me get to that.
2 p.m.
2 p.m. So it'll be February 23rd, 2024 at 2 p.m. All right. Now, as to the counterclaims that you have, what do you intend on doing with those?
I'd still like to pursue it because it's pretty serious still.
The hearing begins with the judge trying to understand the current situation involving the allegedly uninhabitable property. The defendant explains that she and her children are temporarily staying with a neighbor and are preparing to completely vacate the property. The judge makes it clear that moving out quickly is important so the landlord can regain control of the premises and address the reported mold problem.
Have you entered into any discussions with them about that?
I've had communications, but they don't really agree with any of it.
I don't know what the court's record looks like, but it was not listed in what I believe to be the filed supplemental answers to complaint, affirmative defenses, and counterclaim. I don't believe that there was a prayer for relief. Not a specific prayer for relief in that document.
Are there photos of these items you're claiming are damaged?
There's not photos of the specific items, but just from the mold specialist, he told us anything wood, stuffed animals, toys, plastics, anything that it was.
I understand that part. I'm just saying.
I don't have pictures of like the dresser and stuff like that. I mean, I have pictures of like the carpet and.
Let me ask you this. If I were to decide this, how do I know these items that you listed existed?
I mean, that's not really, I mean, it's really just like stuffed animals, toys, a dresser is like the only furniture
I
item.
understand what you're telling me. How do I know they existed?
I get you.
Okay, so we have an answer to that?
I mean, I could preside pictures on the return court date if needed, but yeah, I didn't know, I wasn't thinking on that part.
Was that a rug or was it carpeting that was down in the premises?
It's brand new carpet that we laid when we first moved in and the padding underneath. It was just in that one room.
The case then shifts toward the counterclaim, where the defendant says she wants compensation for damaged belongings and health-related concerns. However, the judge immediately focuses on the evidence. He questions whether there are photographs, receipts, or other proof showing that the claimed belongings actually existed and were damaged. This puts the defendant in a difficult position because simply claiming an item was damaged may not be enough to establish its value in court.
So what's the total amount you're asking for?
From the damage claims or the whole thing?
The whole thing.
It came out to about roughly like 48,000-ish.
And how much of that is damages?
I'd probably say about around 1,500 if I recall properly. I'm not 100%.
1,500 in damages. The rest of it is what?
Mainly pertains to health issues, the environment we were in. I mean, it could have caused some serious issues. We were trying to get mold tested as well, but according to them, if the kids came.
Here's one of the things you're going to have to look at. At some point, you know that mold is there, right?
Correct.
And so at that point that you realize that there's something there, you can't just sit there.
Oh no, once we noticed the mold, we've been trying to move honestly for months now. It's just because with me being self-employed and like the requirements of places, it's
okay. But you can't just sit there and have damages increase.
I agree with that. That's why I made the landlord.
Because it's the law. You have to mitigate those damages. So you're telling me we're trying to move. I mean, the last time I was here. Okay, so last time we were off. I don't know that there was an issue regarding mitigation because there were still people in the premises.
Correct. But from the mold specialist, he could have serviced the property if just the people were out. Because he said he would even have to remedy, the items that are in the rooms too, and see what's savable and what wouldn't be.
So what does that mean?
Like he could come in and remedy the entire property with just.
One of the biggest issues becomes the legal concept of mitigation of damages. The judge explains that once someone knows their belongings are being exposed to harmful conditions, they have a responsibility to take reasonable steps to prevent additional damage. He uses the example of an expensive dresser, explaining that leaving it in a damaging environment could make the eventual loss much greater. The judge emphasizes that a person cannot allow damage to continue and then expect the landlord to pay for the entire loss.
I mean, I don't know when that was damaged.
I got you.
Put another way, if you had said, this place is doing whatever, it's probably damaging all of our stuff, and you guys get yourselves out, you move to a hotel, you then get your property out as best you could, put it in storage, and then say, Mr. Landlord, you need to fix this. That's a whole different ballgame.
I got it.
But that's not what happened here. In fact, the mitigation, so, and again, even at this point, right now, as we sit here today, you still haven't vacated the premises. My point to all of that is, and I just bring up the questions, quite frankly, that the court would be asking about the value of the property. What did you purchase it for? You know, if I had to decide this case, I have to first of all know that the property existed. Put another way, you can't all of a sudden claim landlord's responsible for the diamonds that fell through the floor because they didn't fix the mold and there was a floor, and so now the diamonds are gone. Same thing with the dresser. I have no idea whether it was there.
No, I understand.
Presuming that there would be one, but I don't know. Then it's going to be the condition of that dresser. So that if it was just a cardboard box that we called a dresser, that's a whole different ballgame than if I've got something that
Real fancy.
The judge also questions the large amount being requested in the counterclaim. The defendant estimates the total claim at around $48,000, while only about $1,500 appears to relate directly to damaged property. The remaining amount involves alleged health and environmental concerns. The judge's questions show that proving such a significant claim would require substantial evidence, including documentation of the property, its condition, the losses suffered, and the connection between those losses and the landlord's actions.
if I know that there's damage that's occurring to the dresser, and let's say I know it a year ago when you moved the kids, I can't then just leave that dresser there to presumably get more damage and then blame the landlord.
I get where you're coming from.
If let's say this dresser was $1,000 dresser, if I can get the dresser out a year ago, do some remediation on it, clean it up, and now it might only be worth $800. Okay? Then maybe you can go to the landlord and say, yeah, you know, there was about $200 of damage that occurred to me. That's very different than the same scenario. I had this $1,000 dresser. I just leave it there
And let it get
and
worse.
just let it go to zero where I can't do anything with it, and then say to the landlord, you owe me $1,000. Right?
I get you 100%.
The other thing that you're going to have to realize is, and I don't mean this badly, but it's just a statement. Every man's junk is their treasure, right? There's stuff in my house that has a great deal of value to me. It has no value to anybody else. I don't know why, but it just doesn't.
You're correct.
So some of the stuff. So what I'm going to do is, I had this set for final settlement conference because I was hoping that we could probably get this, but I mean, things were taking their own turn wherever, so it didn't work out as I planned. I'm just going to go to, you know what I'm going to do? No, I'm going to still give you the February 23rd date. And that's really regarding the surrender of the property, right, at 2 p.m. I'm also going to set another date so we can come back on a final settlement conference on the
Rather than immediately pushing the case toward a trial, the judge gives both sides a reality check. He warns that discovery and trial could become a long and extremely stressful process. He encourages the parties to consider whether they can reach a realistic settlement instead of continuing the fight. The judge essentially tells them that while he is prepared to take the case to trial if necessary, resolving the dispute now could save everyone considerable time, money, and frustration.
Have you ever been through the discovery process? Core, okay. So, look. Let me just ask you this. All right. To both of you. What do you guys want with this? I mean, because, and here's the reason, you don't have to answer me, quite frankly, if you don't want to. But here's what I'm saying. I guess what I'm getting at is, you guys are going to get here because at some point I'm going to set a trial, right? But even before we get to the trial part, there's going to be discovery. They're going to want to know certain things that you're claiming. Right? And I would imagine, although sure counsel's probably a much better attorney than I ever was. So he might ask something else. But just the questions that I posed today to you, it's just a small piece of what they're going to be looking. And I just have a feeling, folks, you're going to have one of the most miserable experiences of your entire life. Now, if you want to go through that, that's fine. I'll be here. Right? But I think maybe, and I don't know what the plaintiff's position will be, but maybe you should take some of what I said to you today, come up with something that might be realistic and propose it to them to see if you can resolve it. I really don't think you guys want to go through a trial. If you want to, hop on, let's roll. But I don't think that's what you want to do. I'm going to suggest to you.
Near the end of the hearing, the situation becomes tense when the defendant's mother speaks emotionally about the dispute. The judge reminds her that everyone must remain respectful in the courtroom, even when they strongly disagree with what is being said. He gives her a warning instead of taking immediate action, but makes it very clear that repeated disrespect could result in serious consequences. The hearing ultimately ends with future court dates scheduled and both sides being encouraged to think carefully about how they want to resolve the dispute.
On those two dates and hopefully get it. Yes, go ahead.
Yes, Your Honor. There are some appliances, I don't know how many, but stoves, appliances being kept outside the property from the defendant's self-employment. And I would request that.
That's going to be removed as long as with the trailer that's on there too.
Thank you, Your Honor.
Okay, these are not appliances in the house. This is part of what you do.
Yeah, it's like in a field tucked away. He gave me permission for it, but I understand why he wants it all removed now. Right.
Oh, you did it now. You done said something you wasn't supposed to. Judge is not afraid to send his man to pick you up. Let's find out what happened.
What's your name?
My name is Diana Leck. I am Ryan Halicki's mother.
And did you have something you wanted to say?
Well,
You have a whole lot when you were leaving.
yeah, because it just upsets me because I think it's kind of being pushed over to the material things and his property, when in reality, this issue's been going on.
I understand all of that, ma'am. I've been through every one of these hearings. But one of the things is that people may not like what I say or what I'm telling somebody.
I
But you
understand
will
that.
always leave here in a respectful manner.
I know. I have a big mouth
You
sometimes.
do.
I
And
apologize.
that's why I could hear it. So I'm going to give you this, I'm just going to let you go with a warning this time. But if you come back and you act that way again, that gentleman behind you, that's who you'll be going with. Am I clear?
Yes, sir.
Thank you. You may leave.
Thank you.